IRS is going to obviously seize his property, obviously. So obviously he's going to move court as a man, and he's going to find this Mr. or Mrs. IRS, or find this Bob Jones who acts on behalf of IRS, the commissioner, and he's going to say, you have to come forth and make a claim that I owe a debt.
That's right.
It's that simple. It's going to be that simple. And obviously the IRS commissioner, or the president, or the creator, or the controller of IRS is not going to testify. He doesn't freaking know. He's not going to show up. So he's going to have his own court running, because if he just thinks he's going to battle IRS, he's going to lose, even in the judicial court. So like I said, the whole trick is he's going to move his own court, and when he moves his own court, he's going to say, wait a second, is somebody over there testifying? Is a prosecutor opening his mouth? Did I hear something from the IRS, the United States Attorney? Did I hear something over there? And he's going to be like, well, yeah. It's like, tell him to take the stand as a man and testify that it's true. Anything that's said in my court has got to be testified under oath of affirmation. It's just that simple. My sister did it, 7 years ago, and during a divorce, and knocked 3 of her husband's attorneys out in 5 seconds. Mm-hmm. They couldn't testify, and it's this simple.
Mm-hmm. I love it.
Then the big thing that everybody's got to start to understand is everybody's crying and whining, oh, the clerk won't let me do this, the clerk won't let me do that. I tell them, look, I said, the clerk's forms, just use the form. It's like a UPS form, a Federal Express form, or a whatever it is, FedEx, UPS, Postal mm-hmm. Service form. Mm-hmm. It's just a form you put on top of your case, on top of your package. It doesn't matter how the form looks, just put it on top of your package and put it on top of your case. Just wrap it up and say, page 1. And you just write page 1 and say it's a federal one. It says JS-44 form. Just say page 1, JS-44 form is the easiest for the purpose of the court clerk filing purposes only. And that's it. And then you put your case in, and you make a very simple, cover sheet like that, and just say this case is to remain sealed until it comes forth before the trial by jury. So you don't want anybody to interpret it. This case is to remain sealed until the day it moves into an open court before a trial by jury. That's it. You don't want to deal with the court clerk, her opinion of what their case is about. You don't want to hear what a magistrate's opinion is. You don't care what the other side's opinion is. It's like, look, you want to answer to my claim? That's fine. Answer my claim. You know what? If we can't settle this in 21 days, that's fine. We'll open up the case in 21 days in front of a jury. On the 22nd day, we'll open up in front of the jury. And then we'll try on the suit before the jury. But I am not going to argue and battle with the court clerks anymore. I'm not battling and arguing with the magistrates. I don't care what their opinion is. They're not going to dismiss my suit, my claim. It's because I've never seen it ever where they say the state of California is charging with breaking and entering, a burglary, a robbery. I've never seen Joe Average say to the judge, well, I want you to dismiss the state of the state of California's claim against me of robbery because they failed to present a claim in which a relief could be granted. And the judge said, okay, granted, dismissed. I've never seen anybody just say that. They'll say, no, it's the state of California's case, and the judge will say, I can't touch the state of California's case. So that's why you don't come in as a plaintiff. If you come in as a plaintiff, you're coming in complaining to the judge, and you want the judge, the mommy of the court, to handle your complaint for you. So you're not coming in as a plaintiff, you're coming in as a prosecutor, just like when the state of California comes in after you, they're coming after you as a prosecutor. They're not coming after you as a plaintiff in a criminal case. They'll come after them as a prosecutor.
How do you, and how do you do that?
Just say Karl Lentz, prosecutor. I wrote, a man, Karl Lentz, prosecutor. There you go.
Okay.
That's them. Versus Bob. Versus a man. Versus, like I say, versus a man, Bob Jones, wrongdoer. There you go. It's that simple. No funny spellings. No ridiculous nonsense.
Was this something new? I haven't heard you say this before. I thought you said you're always the plaintiff in all the IRS cases.
Oh, no. Plaintiff, you never heard me say that because plaintiff is a French word for miserable, wretched, or nagging. Mm. No, plaintiff is French for wretched, miserable, nagging, haggard. I'm not miserable. I'm not complaining. I'm not haggard. No, I'm always the prosecutor. I don't mind coming in as a defendant at times. I have no problem. If you want to move your claim against me as a defendant, that's fine because I'm going to move my case against you at the same time. As a prosecutor.
But I think, what maybe I'm getting confused because you said whenever the IRS comes after you, you are the plaintiff.
No, what happens is when you petition their assessment on you, you become the plaintiff. You become the petitioner. You become the moving party.
Mm-hmm.
That's what we say. The IRS will say we're going to take $10,000 from you. Da 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 da. If you don't like our assessment, take this petition form and file it at your local, United States tax court nearest you. You got 10 days to petition. And petition just means to beg and whine and cry to a deity or a supplication of somebody of a higher authority. Petition just means you're begging. You're a beggar.
But I could have sworn I heard you say that, Karl, that if they have a case against you, you don't realize it, but you're the plaintiff.
No, you don't realize it. You're the petitioner.
The petitioner.
Not plaintiff. You're the moving party. You're the one moving the court, and the IRS doesn't have to answer because they're coming in as a defendant, and the defendant can stand mute in this country. They don't have to open their mouth. You can't put the defendant on a witness stand. You can't break their legs. You can't threaten them. You can't do anything. The defendant can stand mute. You have to prove you don't owe the assessment, and you're never going to prove it. It's their judges. It's their judges. It's their rules. It's their everything. You're never going to do it. You can't petition them in their tax court. You got to open up your own court. You got to have the Lentz court at the United States District Court. You got to have the Lentz court at the Federal District Court. You got to have the Lentz court at the Abbott Jones Center, Judicial Center, wherever. Call Lentz court at the Apple Tree. It doesn't matter. It's going to be your court someplace where everybody in that town or that community or the locality recognizes as the local courthouse. It's going to be my court at the courthouse. It's like saying my dance at the dance hall. Dance and dance hall are two different words. If I say we're going to dance or we're going to go to a dance hall, it's two different words. If I say we're going to go to court or we're going to go to courthouse, it's two different words. You people think court and courthouse is the same word. It's not. It doesn't mean the same thing. It's like saying dance and dance hall. It's not the same thing. It's a venue. Where are we going to go? To the dance hall. What are we going to do? Dance. We're going to go to the courthouse. What are we going to do? We're going to put on call court. We're going to put on Lentz court. What does that mean? It's like we're going to do the polka dance at the dance hall, at the venue that everybody knows in town is the dance hall.